All right, thank you very much for coming today. I'm attorney Gloria Allred, and with me is Teri James, and behind her is her husband, formerly her boyfriend, Brandon, and behind me is David Reed, who is our co-counsel, a wonderful attorney from the San Diego area, actually from Newport Beach. And I'll be making a statement, and then Teri will be making a statement, then we'll be happy to answer some questions. We're here today to announce an unusual and important lawsuit on behalf of Teri James against San Diego Christian College, SDCC. We're alleging discrimination against Teri on account of gender, pregnancy, and marital status, to name just a few. Teri, who is 29 years old, worked for SDCC for approximately 2 years from January 12, 2011 to October 19, 2012. She was employed as a financial aid specialist. It was not part of her duties to interact with students at SDCC, except for students enrolled in online classes. Her interaction with the online students was on the telephone. Teri performed her job duties well and was given a very favorable review. In 2012, Teri became pregnant. She was unmarried at the time. Although Teri did not disclose her pregnancy to her employer, there was a rumor on campus that she was pregnant. She was contacted by her supervisor and HR and asked to come to a meeting without being given the reason for the meeting. At the meeting with her supervisor, she was asked if she was pregnant. Teri answered honestly that she was pregnant. At the subsequent meeting with the HR director, her supervisor disclosed that Teri had said she was pregnant. The HR director told her that as a result, she had two options: resign or be terminated. Teri indicated that she knew pregnant women had rights. The HR director indicated that she was not being fired because she was pregnant. Instead, he stated that she was being terminated because she had premarital sex. Teri asked for a day to think about it, and the next day she advised the HR director that she was not resigning. She was then given a termination notice which stated, quote, Teri engaged in activity outside the scope of the handbook and community covenant that does not build up the college's mission. Being an at-will employer, SDCC decided to terminate the relationship between SDCC and Teri, end quote. The community covenant states, quote, the traits that should not inhabit our lives are identified as abuse of anger, malice, jealousy, lust, sexually immoral behavior, including premarital sex, adultery, pornography, and homosexuality, evil desires, prejudice based on race, sex, or socioeconomic status, greed, idolatry, slander, profanity, lying, drunkenness, thievery, and dishonesty, end quote. After her termination, her boyfriend, Brandon James, who had previously worked for SDCC and who was also the father-to-be of Teri's child, was offered a job despite SDCC's knowledge that he had had premarital sex with Teri. Teri and Brandon have since married, but they had to move up their wedding date, originally scheduled for January 19th, 2013, to October 30th, 2012, because Teri's termination caused her to lose her health plan. In order to be added to Brandon's health plan, she had to move the wedding date up by 3 months, depriving her of her anticipated wedding ceremony with friends, with family, and with invited guests. Teri was understandably very upset by her termination. She told her employer, quote, I know pregnant women have rights, end quote. And today, Teri is asserting them. This morning, we filed a lawsuit on behalf of Teri against SDCC, alleging pregnancy discrimination in violation of the Fair Employment and Housing Act in California, gender discrimination in violation of the same act, marital status discrimination in violation of the Fair Employment and Housing Act, gender discrimination in violation of Article 1, Section 8 of the California Constitution, wrongful termination of employment in violation of public policy, invasion of privacy in violation of the California Constitution, unlawful use or disclosure of employee medical information in violation of Confidentiality of Medical Information Act, intentional infliction of emotional distress. We are seeking injunctive relief and damages according to proof at trial. Although the defendant calls itself San Diego Christian College, it is a business registered with the California Secretary of State. As such, it is governed by the California Constitution and laws of California, and we contend that it is not permitted to terminate an employee because the college thinks the premarital sex leading to pregnancy is wrong. Teri James and her husband Brandon, who is 27 years old, are very courageous to speak out against this injustice, and today, Valentine's Day, is the perfect time to do it. Teri is 6 months pregnant, and she feels that her baby is a blessing. She was honest about her pregnancy, and she was not willing to lie about it in order to keep her job. We look forward to litigating this case for Teri so that SDCC and other employers will know that women have rights, and they will assert them if necessary in a court of law. And now it's my pleasure to introduce Teri James.
I am a Christian, and I feel like what San Diego Christian College did to me was hurtful and un-Christ-like. I was unmarried, pregnant woman, and they took away my livelihood. They stripped me of my dignity and humiliated me. I not only lost my source of income and my health insurance to care for myself and my baby through my pregnancy, but I also lost my career and my community. Unexpected pregnancies are hard enough without having to figure out how a pregnant woman is going to pay her bills each month during her pregnancy. Women out there should not have to worry about losing their income and independence just because they are carrying a child. A child is a blessing, and our number one goal is to start our child's life off in a positive light. San Diego Christian College took it into their own hands to judge me for my actions. I do not believe that this is their job, but God's. I do not believe that God would want me to be without a job or health care during my pregnancy. San Diego Christian College did not show any mercy or grace towards me and acted completely un-Christ-like. They made more of a business decision than showing God's love.
We have attached to the lawsuit a copy of the covenant, which I read, and also a copy of their termination. The termination is Exhibit A, and the Exhibit B is the covenant. So this is the covenant right here. And it's the last paragraph on the first page that I read to you as the quote. And then in addition, their termination letter to her is also enclosed for your reference as Exhibit A to the lawsuit, which we filed this morning in the Superior Court for the County of San Diego. So this is their termination, which is Exhibit A to the lawsuit, and which says that Teri engaged in activity outside the scope of the community covenant. And it goes on from there. So we'll be happy to answer any questions.
Did you have to sign something prior to starting your work there saying that you would not do these things? Did you have to sign something? Did they make you?
She did sign the covenant.
Okay, before starting work there?
Yes.
Okay.
I think it's important to note that the reason that I pointed out that she deals with online students only and only on the telephone is, of course, they wouldn't even know that she was pregnant or had engaged in premarital sex. And further, apparently, even the online students don't have to sign the covenant to be an online student. I'm not at this point going to opine on whether they can have their employees sign it. But whether they can terminate someone on the basis of their having had premarital sex, which is an issue having to do with their marital status, and, you know, the other issues is what we think they cannot do. First of all, this is really mainly going to have an adverse impact on women. Because how would they know the couples are having premarital sex? How would they know a man's having premarital sex? The way they know a woman is having premarital sex is if she's not married and she's pregnant and she's showing. So it's more likely that this is going to be inflicted, this type of adverse job action, termination, on a woman, because they'll know that a woman had premarital sex, and they won't know unless a man steps up and said, I have. So we say that's gender discrimination, pregnancy discrimination, and marital status discrimination. We say they cannot do that under the law. Can they just do anything they want? I'm sure that everybody recollects our famous Hunter Tylo case many years ago, where there was a contract that Hunter Tylo had to sign in order to be on Melrose Place, in which, that she had to sign that it would be a violation of her agreement if there was a material change in her appearance and she became pregnant. They argued that's a material change in her appearance. We argued that laws which prohibit pregnancy discrimination do not allow them to terminate her, even if that is a change in her appearance. We won. So these are some of the issues involved. In terms of invasion of privacy, we don't think they even have a right to ask her, are you pregnant? That's an invasion of privacy.
Were you even showing at the time?
No, not at all. When I was asked, I
A
believe.
little louder.
When I was asked, I believe I was a month and a half, so like 8 weeks.
Why do you think they asked you?
I believe they told me that they had heard from multiple sources, that it had come to their attention through multiple sources.
Had you told anyone? You weren't through your first trimester.
I had told two people that were friends of mine that are still continue to be friends of mine, and both of them are vocal about that this was wrong, but I don't know how else other people found out.
These
But
friends
how-
worked at the school also?
But however they found out, they have no right to inquire, and they did inquire. And that's an invasion of privacy as far as we're concerned. Thank you very much for coming.
Congratulations.